So the charge of felon in possession is essentially that you were a felon, a convicted felon, and that now you are in possession of a firearm. It is the most common firearms charge in Milwaukee County that I've encountered. What this means is that as a convicted felon, you are barred from possessing a firearm. Now, the key in understanding this particular charge is that you don't necessarily even have to own this firearm, nor would you have had to even hold it in order to be in possession of it. So it is critical that you understand not to be near a firearm if you are a convicted felon. And this is where individuals then find themselves in trouble or facing criminal charges. Because of this particular charge, it is considered a felony matter. So you are a convicted felon, and now if you are near or in possession of a firearm, then you would be facing a felony charge. So the penalties for facing a felon in possession of a firearm charge is pretty severe. It is a felony conviction, and then on top of it, you're facing up to 10 years maximum of incarceration, that's prison time, and $25,000 fine or both. So it can be pretty serious, and because of the penalties that you're facing, you need to have an attorney. It is always best to have an attorney with you. So one of the defenses is, were you actually in possession of this firearm? Oftentimes, for example, you could be charged with this crime because it was found in your home without even having knowledge that this firearm was in your home. And so the question becomes then, did you have knowledge of this firearm? Not only did you have knowledge, but did you have the intent to possess it or to have authority over the firearm? So one of the elements of the crime that they must prove, in addition to proving that you are a convicted felon, is whether or not you had the ability to have authority over this firearm. And when you can prove, when your attorney helps to prove that you did not have the authority to exercise power over this weapon, then that can be a defense to your case. So the reasons that a prosecutor would possibly lower your charges in a felon in possession case would be, it would relate to your criminal history, your criminal background. It relates to your character. It relates to the facts of the case. There are many mitigating reasons, and by mitigating, what I mean is that perhaps it was found in a home that's not your home, but you were sleeping in a bedroom. That might be a particular situation where you didn't have knowledge of it, you didn't have any intent to exercise authority over it, and so then we use the facts of the case in order to help you so that we can decrease the charges and explain to the state the reasons why you should not have been charged with a crime, or if you are charged with a crime, to amend it to something lower.